Hi, this is AIW370 International Trade Law. Today we are introducing a new invention, the solar panel backpack, and we hope to register a patent for it in the United States and copyright the photos we took of the solar panel backpack. This is our content. First, we need to introduce the solo backpack, and then we will introduce the laws, procedural guidelines for the patent registration, and copyright of pictures for the solo backpack. First, we will introduce this backpack. This backpack with a built-in solar panel to charge device on the go and let people reduce the plight of mobile phone battery.
The United States have comprehensive laws and regulations to protect intellectual property, covering patents, trademarks, copyrights, and trade secrets. The Patent Act, governed by Title 35 of United States Code 35 U.S.C., details procedure for patent applications, grants, transfers, and infringement, managed by the United States Patent and Trademark Office. The Lanham Act, found in Title 15 U.S.C., addresses trademark registration, protection, and infringement, with disputes handled by the Trademark Trial and Appeal Board. The Copyright Act of 1976, under Title 17 U.S.C., outlines copyright protection, registration, transfer, and infringement overseen by the U.S. Copyright Office for Trade Secrets, and the Uniform Trade Secret Act, adopted by most states, and the Defend Trade Secret Act of 2016, which amends the Economic Espionage Act, allows for federal lawsuits over trade secret infringement. And these laws form a robust system to encourage innovation and creativity while safeguarding the rights and creators and owners. Violating U.S. patent and copyright laws can lead to serious problems. When someone uses makes, sells, or imports a patented innovation without permission, it's called patent infringement. The patent owner can take the infringed to court. If court finds that the patent was infringed, the infringed might have to pay for the damage. And financially, patent infringement can be devastating. The penalties and legal fees can add up to millions of dollars, potentially bankrupting the infringed. This financial strain isn't the only issue. Infringement can also lead losing market share and damaging the company's reputation. Infringing on patents can also damage relationships with other businesses, making it difficult to form new partnerships or collaborations. Thank you.
Hello everyone, my name is Tristan and today I'll talk about the guidelines for patent and copyright registration. Protection of intellectual property is important because it helps keep your ideas safe and encourage innovation. When your creations are protected, you have exclusive rights to use and benefit from them. So, let's start with patents. Patents give you exclusive rights to your invention for 20 years. Let's take a look at the steps. So first of all, eligibility. Your invention must be new, useful, and not obvious to someone skilled in that field. It should not have been disclosed publicly before applying. Step number 2, types of patents. There are 3 types of patents: utility patents for new and useful inventions, design patents for original and ornamental designs, and plant patents for new varieties of plants. Step number 3, prior art search. This involves checking existing patents and publications to ensure your invention is unique and hasn't been patented before. Step number 4, provisional patent application or PPA. This is temporary application that gives you a year to file a full patent application. It helps establish an early filing date. Step number 5, non-provisional patent application. This is the formal application, which includes detailed descriptions, claims about the inventions, drawings, and an oath of declaration by the inventor. Step number 6, and the last step, examination and maintenance. After filing a patent, an examiner reviews your application. If it is approved, you must pay a maintenance fee at a regular interval to keep the patent active. So let's move on to the copyright registration steps and go broadly over them. Copyright protects original works like books and music and arts. Step number 1 is also eligibility. Your work must be original and fixed in a tangible medium, like being written down or recorded. Step number 2, application process. To register and complete or an application form, pay a fee and submit a copy of your work to the Copyright Office. This can be done online. And the last step number 3, benefits. Register your copyright gives you the legal right to sue for infringement, which creates a public record of your claim and makes you eligible for statutory damages and attorney's fees if you win in court. So, to come to a conclusion, protecting your ideas with patents and copyrights is crucial for encouraging innovation. By following these steps, you can keep your work safe and enjoy the benefits of your creativity and hard work. Thank you for listening.
So I will be talking about now how the solar backpack can actually apply for the patent registration, and there are 8 steps which I will discuss. So the first step is to determine what the type of patent it is. So there are 3 types: utility, design, and plant patent. And the utility patent are for new and useful innovations. However, these patents, they are valid for 20 years, and they do these are the only patents that require a maintenance fee, which you have to pay at the 3.5 years, 7.5, and 11.5 years after the grant of the patent. Then there's also the design patent for original and ornamental design, which is valid for 15 years and there are no maintenance fees. And then for the plant patents, it's for newly discovered plants, and this is also valid for 20 years and there are no maintenance fees required. So in this case, solar backpack actually applies to being a utility patent. Then you have to see the preliminary steps. So first you have to, this is before actually applying for patents. So you have to conduct patent research to see whether there are other backpacks that exist with similar solar panels or similar technologies. You can do this by looking it up on the USTPO database, or you can verify the novelty of the invention through checking similar consumer products and their patent details. And then also you have to document invention. So you have to keep a detailed record of the invention process. So this includes like diagrams, the specifications, all the research and modifications, and the test. So then lastly, you have to determine the patentability. So you have to see whether it actually meets the criteria of novelty, non-obvious, and utility. So now at step 3, you have to choose the application types. There are 2 types: the professional patent application and the non-professional patent application. So in this case, the PPA, the professional patent application, is actually better to apply for. For the solar backpack, this is because it's more cost effective. It's quicker, so it provides immediate patent pending status. This means that it has 12 months to, so 1 year temporary protection. So this allows you to make any more developments at your investment. Besides that,
it's more simple to apply for. So overall, the PPA is better. And then you also have to look at the application components. So this includes like a summary what the of what the of what the invention actually is, and also you have to show its advantages and just a broad explanation on the invention itself. And you also have to make maybe visual representation, so you have to show how the invention looks like, and also the statement confirming the inventor's claim of the invention. So at step 4, then you file for the patent application. This is through the USPTO EFS web or through the mail, and you pay the required fees. So after you have applied for the patent, you will there's an initial review. So the USPTO, they assign an examiner to review the application for the completeness and the compliance. So if to see if it meets all the formal requirements. And then there's also a substantive examination. So here the examination will conduct a more detailed review to determine if the invention meets all the patentability criteria. And if it's not that, then the examiner may also issue an office action. This allows to include more approval or rejection or request more information. So for step 6, if there is a responding to the office action, so if there has been a file for office actions, you can address any objections or rejections by amend claim or provide more information on your invention and also more arguments. So after that, there's at the final decision, your patent is either approved or rejected. So if it's approved, then a notice of allowance will be issued, and then you pay the required issue fee, and the patent will be granted. But if it's your patent is rejected, you can file an appeal with the PTAB, which stands for Patent Trial and Appeal Board, or you can just refile the whole process of the application. So if it is approved, for the solar backpack, as it's a utility patent, they have to pay the maintenance fees, which is, as I stated already, at 3.5, 7.5, and 11.5 years after the grant of the patent. And the patent owner can also um, get an enforcement fee, which he is responsible for. So this helps for enforce the patent rights against any infringers.
There are 7 steps for the copyright registration. Determine copyright or patent. Copyright registration types: application and registration, acceptance and review, approved application, issuance of copyright certificate, copyright protection. The first to 6 steps are the key steps for copyright registration. First of all, we need to distinguish between copyright and patents. For patents, it must be a complete invention. It can be any new and useful process. We have created a brand new solar panel backpack. This design represents a function change. For copyright, it is a description such as a painting, a photo, a sketch. For example, we capture a photo of a solar backpack charge a mobile phone through a camera, so we can register a copyright for this photo. In the United States, there are about 6 types of copyrights. The first is photographic works, which include new photos, selfies, family photos. The second is the motion pictures, which mainly include the movies, animations, and videos we are familiar with. The second is the other digital works, works used or distributed on the Internet, such as computer programs, databases, blogs, and so on. The fourth is literary works, which mainly include poetry, journals, and other literary works. but the names and titles cannot be protected by copyrights. The fifth is performing arts, which are usually the music and stage performers we are familiar with. The last is visual arts. Journal books, works of art, jewelry, all belongs to visual arts. The third step is apply for registration. The first step is to apply. Applicants need to apply to the United States Copyright Office, make a copy of the work and upload it. Use the electronic copyright office to fill online and fill in the application form. The application form needs to be signed by the applicants, and the process should be applied by a legal person or a natural person. After the application approved, a certain application fee needs to be paid. The second is the registration. There are three ways to register: online registration, fill out paper forms, and scan QR code and print applicants' forms. Among them, online registration is the fastest and most popular among the public. Registration takes about 3 months. It is important to note that pre-registration is allowed for unpublished similar works, but this process is not formal registration. Pre-registration needs to meet three conditions. First, the work is unpublished. Second, the work must be prepared for commercial distribution in physical or digital format. The work must be in one of the six major categories. The first step is acceptance and review. The copyright examiner will review the application to determine whether the work can be registered. The examiner will decide whether to pass the registration based on the category of copyright, originality, deposit procedures followed, and application procedures. The fifth step is the approved application. This step depends on whether the work you submit complies with legal regulations and formal requirements. If the work does not constitute a copyrighted work, the United States Copyright Office has the right to reject the application and notify the applicants in writing. The applicants also can conduct a review and appeal after being rejected. The last two steps are issue of copyright certification and copyright protection. Copyright certification means a public record that can be used to claim copyright in court and sue for infringement. The owner of the copyrighted work can seek protection from the U.S. Customs to prohibit the import of infringing works. That's all the process of copyright registration in the United States. A solo backpack patent registration secures legal rights to an innovative backpack invention that uses solar panels to harness the sun energy, potentially charging electronic devices while on the go. This secures the inventor's patent rights to make, use, and sell the invention. On the other hand, a copyright registration protects the creative expression of the backpack photos. This registration ensures that the creator retains control over how those materials are used, preventing unauthorized copying or distributing. Together, these registrations provide comprehensive intellectual property protection that promotes product innovation and safeguards the interests of inventors. Thank you for your listening.